Hi everyone, my name is Crystal. Shijie, Iji, and Ping is with me today.
Hi, I'm Shijie.
Hi, I'm Ijie.
Hi, I'm Paying.
So we're going to talk about a case which named Morgan Crucible versus Hill Samuel Bank Limited 1991. These are a few topics that we are going to share later. Let's first look at the fact of this case. In year 1985, the plaintiffs Morgan Crucible Company were bidding to acquire a third-party company, which is the Caparo. Hill Samuel Bank Limited gave some advice and suggested Morgan to take over Caparo. Hill Samuel Bank then posted a few circulars to its shareholders expressly or impliedly referring to its most recent auditor's accounts. And one of these circulars also contained a profit forecast. Morgan Crucible did not make their decision carefully, and they subsequently increased its offer, which was accepted by the board of Hill Samuel Bank. During the bidding process, Hill Samuel Bank made several negligent misrepresentations to Caparo, which resulted Morgan Crucible suffering a profit loss. After the completion of the acquisition, Morgan Crucible brought an action against the target company's directors, financial advisors, and auditors, claiming that the accounting policy used in the financial statements and profit forecast referred to in the defense circulars were negligently prepared and misleading.
Next, I will share about the issue of this case. The issue was whether a party advising a company owed a duty of care to other companies with whom those receiving the advice subsequently dealt to ensure that the advice provided was accurate. Just like when Hugh Samuel was advising Morgan Crucible, Hugh Samuel had a duty of care to other companies that they are contacted recently to ensure the advice was accurate. The special relationship between an auditor and a bank means that a duty of care could extend even to a second bank with its own auditors. In determining whether there had been an assumption of responsibility. After the completion of the acquisition, Morgan Crucible brought an action against the target company's director, financial advisor, and auditors, claiming that the accounting policies used in the financial statement and profit forecast referred to the defense circulars were negligently prepared and misleading.
Now I would like to explain the outcome in this case. The Court of Appeals held that on the fact of this case, a duty of care did exist. The key feature in determining whether a duty of care existed was that at the time the advice was given, Health Summer Bank was aware of Morgan's Crucible's identity and the nature of their business or dealings with Caparo. In this case, the court set out the procedure for cancelling and applications for RSC Article 18, Section 19, Paragraph 1A, because the court must assume on being examined that each fact presented, unless clearly unprovable, is true and can be proved at trial. In some case, the court may find these assumptions somewhat unrealistic, but it must still be made. The court set out the main principle under which a party can be held liable for financial loss caused by negligence. The judge said that in this case, in order to determine whether there is a duty of care in the case of a negligent declaration, the knowledge, intent, and purpose of the parties is a process of concept, meaning that they are very important factors. True, by no means the only one, the only factor in considering proximity, fairness, and reasonableness. The judge attached great importance to the city code. After referring to some of the above rules, he also explained that it was clear from the tenor of these rules that the purpose of all the defense documents were rather to accept the offer to advise the shareholders and that there was no indications that they were intended to guide shareholders and bidders. Moreover, the judge found that the reason the House of Lords was willing to find the duty of care in Smith but not in Caparo was because of the different nature of the economic relationship and market between the parties. In this context, he drew attention to some difference in the economic relationship between the parties in these two cases and the parties in the present case. He argued that this difference support his view that it is not just unreasonable to hold that a duty of care exists in this case. However, the court also suggests that it would be relatively low in this context for conduct below this standard to be considered negligent. It is not enough to prove that the information was misleading or highly misleading, as the defendants should not be deemed to have made a warranty as to the accuracy of the information. Rather, it is necessary to prove that they fail to exercise due care.
Our group was agreed to the outcome of this case. The first reason of us was Hugh Samuel Bank gave advice that led Morgan Crucible to quote a higher price to acquire Caparo. Since Morgan Crucible was very reliant on Hugh Samuel Bank and thereby suffered a heavy loss like over 50 million pounds. In our opinion, all parties to a takeover transaction must use every endeavor to prevent the creation of a false market in the securities of an offer or offering company. Both parties that are involved in such transaction must ensure that statements are not made which may mislead shareholders or the market.
Other than that, there was no black and white proven that Hill Samuel Bank has given advice to Morgan Crucible regarding the acquisition of Caparo. Besides, when Morgan Crucible and Hill Samuel Bank signed the contract of acquiring Caparo, there was no third party presented, and Morgan Crucible was convinced constantly by Hill Samuel Bank. This demonstrates that there was no professional advice from the third party, which may lead Morgan Crucible to consider not taking over the company.
Morgan Crucible did not make their consideration carefully. For example, they did not have enough information about the company, yet acquired Caparo directly. After Morgan Crucible took over Caparo, they did not do a financial forecast and research about the company. This led them to have no corresponding plan to solve the financial problem. Hence, they faced the issue of financial loss.
Morgan Crucible had their own independent advisor, but the advisor team did not take responsibility on this project. They did not know how much of the information on the account and profit forecast. The information was presumably available to the Hill Samuel Bank alone. This case is considered as negligent. The defendant should not be treated as having warranted the accuracy of the information. Hence, it is not sufficient to show that the information was misleading or highly misleading. Now, I would like to explain the similar case. ADT versus BDO by the Hamley case happened in 1995. It's similar to the case Morgan Crucible Corporation Public Limited Company versus Hill Samuel Bank. The High Court has recently awarded £105 million, including interest and costs against the partner of BDO. The action arose out of ADT acquisition of Britannia Security Group, which named BSG. BDO by the Handling, which named BDO, was one of the BSG's joint auditor and has been involved in an audit of BSG's 1989 account. During a meeting with ADT, BDO's audit partner confirmed to ADT at its request that he would stand by their account and that he was aware of nothing else which ADT should be told. The audit turned out to have been negligently performed and ADT suffered in loss in making the acquisition. ADT claimed that but for the representation made by BDO, it would not have proceeded with the acquisition, or at least it would have proceeded on different terms. In both of these cases, the negligence of the second party caused the plaintiff to a profit loss. Prior to the acquisition, ADT made it clear to BDO that the final hurdle before making the offer was to obtain certain assurances from BDO. By giving the confirmation, the auditor assumed that responsibility for the reliability of the account to ADT. ADT were relying on the accuracy of the account to go ahead with the bid. In the same position, Morgan Crucible sought to recover their losses from defendant, which is Samuel Bank. During the bidding process, the defendant made a number of negligent misrepresentations to the third-party company, which resulted in the plaintiff suffering a loss. The outcome of these two cases is different. The result of the case ADT and BDO is successful. The High Court has recently awarded $105 million against partner of BDO by the Hamlin. In contrast, the case of Morgan Crucible and Hill Samuel Bank is unsuccessful. The Court of Appeal held that a duty of care did exist on the fact of the case. All the allegations were put in issue by the defendants was massive discovery. The action was set down for trial in January 1991 with an estimated length of 10 weeks.
So there are few different points between ADT versus BDO case. And Morgan Crucible versus Hill Samuel Bank. First, ADT has clearly required BDO that they wanted guarantee and made it clear to BDO that the final hurdle before making the offer was obtain certain assurance from BDO. At the same time, the auditors of BDO also promised that the ADT will receive the full and complete information of Britannia Security Group. They will be vigilant and ensure that there is nothing missed for ADT. Although Hill Samuel was responsible to the profit forecast, and all of them owe a duty of care to Morgan Crucible. But Morgan Crucible relied on their suggestion and subsequently increased their bid. Since the statement and forecast were negligently prepared, the quiet price suffered a heavy blow.
The English High Court decided that BDO, through the representations made by its audit partner, had assumed responsibility towards ADT for the accuracy of the audited accounts. In particular, the judge said, if the audit partner had insisted on a disclaimer, this would have been regarded as a red flag by ADT, which would then have made further inquiries. The case demonstrates how the auditors of a target company can incur colossal liabilities towards a prospective purchaser as a result of unguarded assurances. This case highlights the need for auditors to protect themselves either via a disclaimer or to abstain from giving such assurance in this circumstance. And this brings us to the end of our presentation. Thank you for listening.
Thank
Thank you.
you.